Hello, everyone. Good evening, good morning, good afternoon. Welcome to our webinar, Looking Back and Looking Ahead, Give Justice to Nuclear Victims, co-organized by the IALANA, International Association of Lawyers Against Nuclear Arms, and JALANA, Japan Association of Lawyers Against Nuclear Arms. I am HIROKO TAKAHASHI, moderator of the first session. I'm a historian and I'm teaching history at Nara University and studying US history and global hibakusha issues. In this first session, we look back on the history, learning from the experiences of lawyers who have supported victims of atomic bombs and nuclear testing. This first session consists of 3 parts. 1, opening and introductory remarks. 2, presentation by 3 lawyers who have supported suffering people by the atomic bombs and nuclear tests. 3, questions and answers. So first, we'd like to ask Ms. KAZUE MORI, lawyer and the JALANA Secretary General, to make opening introductory remarks.
Thank you for the introduction. Good morning and good afternoon and good evening, everyone. I'm KAZUE MORI, Secretary General of the Japan Association of Lawyers Against Nuclear Arms, also known as JALANA. I'd like to thank everyone for attending this webinar. On January 22nd, 2021, the Treaty on the Prohibition of Nuclear Weapons, known as the TPNW, entered into force. The TPNW was a long-time wish for the victims of the atomic bombs and nuclear testing, including atomic bomb survivors who are known in Japanese as hibakusha. In Article 6, the TPNW sets forth obligations to assist victims of the testing and use of nuclear weapons, and to perform environmental remediation of areas affected by testing and use. In Article 7, it also requires state parties in a position to do so, to help affected state parties with victim assistance and environmental remediation. These provisions are important because they concretely recognize and address the unacceptable suffering and devastation that have resulted from the use and testing of nuclear arms, and which could result again if current trends in global affairs are not reversed. In the first session in this webinar, we learn from the experience of lawyers who have supported victims of the atomic bombs and nuclear testing, including hibakusha in Japan and South Korea. We also learn about the Bikini occupational accident lawsuit. In the second session of this webinar, speakers will tell us about the future of victim assistance and environmental remediation based on Articles 6 and 7 of the TPNW, about the human rights approach for nuclear disarmament, and about a proposal for environmental remediation. I have no doubt that we will learn much from this webinar. Thank you for your attention, and let's get started.
Thank you very much, Ms. Mori. So the next speaker is Mr. Sasaki Takeya, co-president of IALANA, speaking about the struggle of Japanese lawyers to support A-bomb survivors. So Mr. Sasaki, the floor is yours.
Good day or good evening to everyone, where you are. I'm Takeya Sasaki, a lawyer in Hiroshima, where I was born and raised. Having had contact with many hibakusha, I now serve as one of the co-presidents of International Association of Lawyers Against Nuclear Arms, as also known as IALANA. ここからは日本語でいきます。
In the closing days of the Second World War, Japan had no fighter planes and had no battleships, no sea supremacy. Tokyo and many of the cities, towns, and villages on the main islands had been attacked in air raids. No later than July 1945, the defeat of Japanese army was imminent, at which time the atomic bomb was dropped. It was a clear, beautiful day in Hiroshima on the morning of the August 6th. At that time, I lived in a village that was 31.5 kilometers east of Ground Zero. It was 10 minutes after 8 when 3 bombers flew overhead at a distance of 1.5 kilometers away from my house. 5 minutes later, the atomic bomb exploded 600 meters above ground of 160 meters southeast of the A-bomb dome. It was the tragedy of Hiroshima. On that day, I witnessed the fearsome burst of orange light and heard the deafening explosion, and I saw the mushroom cloud with my own eyes. The A-bomb fireball produced a supersonic shockwave which destroyed houses, set them afire with heat rays, and turned the city into a giant conflagration whose flames were fanned by the blast. People exposed to strong radiation died instantly, while others were crushed to death under toppled buildings, blown away like pieces of paper by the shock wave, scorched by heat rays, and burned to death while frantically trying to escape. Hiroshima had become a living hell. Just that one small atomic bomb called Little Boy killed about 140,000 people out of Hiroshima's total population of 350,000 by the end of 1945. In Nagasaki, one bomb killed 74,000 of the population of 270,000. In the post-war years, the hibakusha have continued living in fear of light and fire, of sound and wind, and of atomic bomb sickness caused by radiation. The world now has 13,000 modern nuclear weapons. While Putin has invaded Ukraine, threatened to use nuclear weapons and attack the nuclear power plants, some politicians have started to advocate nuclear sharing. It's an extraordinary situation. In the post-war period, the Japanese government provided no relief to the hibakusha for more than 10 years. In March 1954, at Bikini Atoll, the United States tested a hydrogen bomb that was 940 times more powerful than the Hiroshima-type bomb. The movement in opposition to atomic and hydrogen bombs experienced a groundswell on this occasion, and at this juncture, the hibakusha realized that they had to unite in solidarity. In August 1956, the hibakusha founded the Japan Confederation of ANH Bomb Sufferers Organizations, Hidankyo. Since that time, Hidankyo has demanded the government's livelihood protection and continued to advocate that humanity and nuclear weapons cannot coexist. As this trend played out, the A-bomb survivors' medical care law was enacted in April 1957. This enabled the hibakusha to get health diagnosis at government expenses, and if they are certified to have A-bomb-related sickness, they can receive medical treatment free of charge. However, they could not receive livelihood protection or compensation for health damage. The Japan Federation of Bar Associations, to which all lawyers belong, released a report on a proposed atomic bomb survivors' aid law in December 1974. And at its general meeting in November 1979, it passed a resolution urging the government to quickly enact an aid law based on the principle of state compensation. The Atomic Bomb Survivors Relief Law was finally enacted in December 1994. Under the support system that was created, if the illness of the hibakusha is certified as atomic bomb-related sickness, then the hibakusha can receive a special medical care allowance of 142,170 yen, about 1,000 euro monthly. And if the illness is cured, a special allowance of 52,500 yen, about 400 euros, can be received. Further, if a hibakusha suffers from any of 11 specified diseases, including liver dysfunction, that person is paid a monthly health management allowance. Mr. Ryuichi Shimoda, who had lost 5 children aged 16, 12, 10, 7, and 4 at the time at 1.4 kilometers from Ground Zero at Hiroshima, survived with his wife and 2-year-old child. He filed a lawsuit in 1955 against the government, seeking compensation from the government for the pain and suffering and payment of solatium because of the atomic bombing. Lawyers put their heart and soul into this lawsuit to support him. The court's decision in December 1963 was the first in the world to conclude that the dropping of cruel bombs violated the basic principle of warfare, that one must not cause unnecessary suffering, and that because the bombs were cruel weapons which inflicted unnecessary suffering, they violated international law. This is known widely by scholars of international law as the Shimoda case. The prohibition of causing unnecessary suffering, to which the decision refers, means combatants. Naturally, absolutely no suffering should be inflicted on non-combatants or civilians. To be certified as having airborne-related illness requires proof of the onset of the illness as well as of being under medical treatment for that. Some hibakusha individually had to file lawsuits to achieve the official recognition on their status. Here I give some examples. Mr. Ishida Akira, who was 17 years old at the time, was in a streetcar 710 meters from Ground Zero in Hiroshima. He developed cataracts, but the government turned down his application to certify his condition as atomic bomb sickness. He filed a lawsuit, and in July 1976, he won the first court victory for the atomic bomb sickness certification. I too served as counsel. Second is Ms. Matsuya's case. When Ms. Matsuya Hireko was 3 years old and 5 months old, she was caught in the bombing 2.45 kilometers from Ground Zero in Nagasaki. A roof tile blown by the shock wave struck her in the head, producing a depressed fracture in her cranium. As a result, she suffered right hemiparesis and head trauma. The government did not recognize this as atomic bomb sickness. After victories in Nagasaki District Court and Fukuoka High Court in July 2000, the Supreme Court recognized that the bombing was the cause of her illness, judging comprehensively by her condition at the time of the bombing, the subsequent symptoms, and other factors. The victory was finalized by the court's decision that the current necessity of medical treatment could be recognized if drug therapy, physical therapy, or other treatment was in fact needed to ease her condition. This ruling was welcomed by all hibakusha as an extremely valuable judgment. Mr. Takeya Konishi was 19 years old and 1.8 kilometers away from Hiroshima Ground Zero, and he had been suffering from illness, including leukopenia. He submitted a self-written petition to Kyoto District Court, and he then obtained the support of lawyers and won victories in Kyoto District Court in November 1998 and Osaka High Court 2 years later. Mr. Kazuo Azuma, who at the age 16 was part of the student mobilization at the factory 3 kilometers from Ground Zero in Nagasaki. He applied for certification due to impaired liver function but was turned down. Subsequently, he was victorious in Tokyo District Court and Tokyo High Court, and the judgment was finalized in April 2005. So winning these court decisions took many years and the efforts of many Japanese lawyers. In 1992, IALANA proposed the World Court Project in a bid to pass judgment at the International Court of Justice on cruel and hellish nuclear weapons. In response, we in Japan established the Japan Association of Lawyers Against Nuclear Arms 2 years later. We held many public lectures and increased awareness of the general public on this matter. In May 1995, we visited the ICJ to communicate the reality of the atomic bombing by presenting to the 14 judges and the ICJ library with photographs of the airborne aftermath, videos, hibakusha testimonies, anthologies, articles, and other materials which describe the tragedies of Hiroshima and Nagasaki. We also asked the judges to visit Hiroshima and Nagasaki. We found out that although the ICJ had obtained the opinions of witnesses and advisors in relation to some disputes over international borders. So after returning to Japan, we pressed the Japanese government to have the mayors of Hiroshima and Nagasaki cities and hibakusha appear as court advisors and submit photographs of the atomic bombing aftermath as evidence, but the government did not agree. The Republic of Nauru had submitted an opinion to the SEJ, arguing that the use and threat of nuclear weapons, the use of nuclear weapons are illegal. So we encouraged Nauru to ask that the mayors of Hiroshima and Nagasaki to be called as court advisors. I received a telephone call from New Zealand lawyer who was representing Nauru. He wondered if the mayor of Hiroshima would consent to be a witness. And on September the 5th, France conducted a nuclear test of Muroa Atoll despite objections, but opinions submitted to the ICJ by the governments of Australia and New Zealand were lukewarm. So 3 people, including myself, asked the governments of Australia and New Zealand to issue stronger worded opinions, and then indeed they changed their opinions. Those 2 countries took action in response to a single fax message from the lawyers. We were surprised and also moved. The Japanese government was alarmed because it would lose face if the mayors of Hiroshima and Nagasaki appeared in court at the behest of other governments. So it requested that the mayors speak as advisors. On November the 7th, the mayors related the tragedies of Hiroshima and Nagasaki in ICJ, Grand Hall of Justice. Then the ICJ issued an advisory opinion on July 1996. The paragraph E of the dispositive states that the threat or use of nuclear weapons would generally be illegal, and paragraph F states there exists an obligation to pursue in good faith and bring to a conclusion negotiations leading to nuclear disarmament. And it was 25 years later, in January 2021, that the Treaty on the Prohibition of Nuclear Weapons entered into force. Article 6 of the treaty includes provisions for the support of the hibakusha. It states in part, each state party shall, with respect to individuals under its jurisdiction who are affected by the use or testing of nuclear weapons, adequately provide assistance. These hibakusha wanted the government to recognize their cancers, leukemia, heart diseases, and other diseases caused by the atomic bombings. In 2005, they collectively filed a lawsuit against the Japanese government at different parts of Japan. The government repeatedly claimed that the people physically affected by radiation are those who were within only 2 kilometers of ground zero and were exposed to the initial radiation only, but that the people farther away from ground zero and those who entered Hiroshima after the bombing were not affected. So the government underestimated impacts, including the effect of residual radiation. Through many judgments in our lawsuits, we successfully forced the governments to recognize not only the direct exposure of initial radiation, but also exposure to radioactive fallout and residual radiation caused genetic damage by high-energy alpha rays emitted from the radioactive substances taken into human body by breathing, eating, or drinking in the radioactive environment. We won 18 court victories in a row. Thanks to that string of successes, on August 6, 2009, 64 years after the atomic bombing, hibakusha signed a confirmation note with the Prime Minister and made him promise to take action that would avert such lawsuits. The Prime Minister apologized to the hibakusha. The victory rate for these collective lawsuits was 91.2%. But around 2014, with substantial increase in the number of certified hibakusha, the government launched an attempt to uphold stricter rules for determining the need for medical treatment, which was one of the requirements for certification. By this means, the government turned down applications from people who would otherwise have been certified as hibakusha. This led to the normal hibakusha lawsuits filed by 120 hibakusha as plaintiffs. These lawsuits either ended in victories or led to resolutions based on new certification criteria. The victory rate was 77.1%. After the bombings, the radioactive black rain fell on a large part of northwest Hiroshima city. Those who encountered the black rain filed the collective lawsuit seeking hibakusha certification. In July last year, The victorious ruling at Hiroshima High Court, declaring all 84 plaintiffs to be hibakusha, was finalized, and procedures to issue the A-bomb survivor certificates to them have begun. In sum, we have realized some big successes, lawsuits to gain atomic bomb sickness certification shattered the myth that only the initial radiation dose was important.
Thank you for your attention.
Thank you very much, Mr. Sasaki. So next speaker is Mr. Bongtae. We have long worked for the support of the Korean A-bomb survivors.
I'm very happy to be here.
I'm going to talk about how Korean hibakusha were formulated, created. So by the atomic bomb dropped by the US forces on Hiroshima on August 6, 1945, and Nagasaki on August 9th, people of Chosun North Koreans were victimized. And we don't really know the correct number of Korean hibakusha, but there are about 70,000 hibakusha, including 40,000 people who died. So those number is relatively about 10% of those in Japanese hibakusha. And those who died, actually, 1/6 were Koreans. So you can see the chart here. You can compare the number of Korean hibakusha as well as Japanese hibakusha. And there were about 30,000 people who survived among Korean hibakusha. And then there are about 23,000 people who returned to Korean Peninsula, including 2,000 who went to North Korea after the bombing. But we don't know how many are still surviving in North Korea because we were divided into the two countries. So the Korean hibakusha are bearing the cross of the 20th century, symbolized by imperialism and nuclear weapons. They are often referred to and recognized as the triple victims, which means they have suffered from enforced mobilization, atomic bomb, and neglection of the public. So that's the meaning of the triple victims. So in December last year, at the end of the last year, 1,992 people are registered as members of the Korean Atomic Bomb Victims Association. So that's the situation of Korean hibakusha in South Korea. So I'd like to move on to the next topic. If you can move on to the... There you are. You can see here, you can see the English text at the bottom of the slide. So right now, the Korean hibakusha have not received any apology or compensation from the US government for dropping the atomic bombs or the Japanese government for provoking the Japanese war. So we have not even able to receive any apology, the word of apology from the Japan or the US. Can you move a little bit down? So as you can see, my presentation in this text, can you move down a little further? Okay, there you are. So Korean Hibakusha, they have not been able to receive any apology from the US or the Japanese governments. So there are many fields that we are fighting. They are fighting for their justice. So as Mr. Sasaki mentioned before, in Japan, there was Japan's atomic bomb survivors support law was established in Japan. So they are trying to eradicate the discrimination that emerged from the atomic bomb survivors support law in Japan. So that's the lawsuit that they are fighting in Japan. And in Korea, they are fighting a lawsuit against Mitsubishi Heavy Industries for damages, and also the lawsuit for the disclosure of documents of the Korea-Japan talks, and a constitutional petition with the Constitutional Court of Korea. And also the third struggle that they are fighting is a lawsuit against the US government and related companies. So, which means that they are fighting against the Japanese company, against the Korean government, and as well against the Japanese government, US government, sorry, and related companies. So I would like to talk about the litigation for damages against Mitsubishi Heavy Industries. So the atomic bomb victims in Hiroshima, Mitsubishi Heavy Industries, they filed a lawsuit against the company. They were forcibly mobilized to work at the Mitsubishi Heavy Industries during the wartime, and they filed a lawsuit on May 1st, 2000 with the Busan District Court in Korea, seeking an apology and damage caused by forced mobilization, forced labor, and failure to aid after the exposure to radiation. So on November 29th, 2018, the Supreme Court of Korea reached a final judgment in favor of the plaintiffs, granting damages against the defendant company. However, the Mitsubishi Heavy Industry has not been able to respond positively to this lawsuit judgment. They totally ignore this decision by the Supreme Court of Korea, supported by the Japanese government. And also, what kind of lawsuit they are fighting against South Korean government? I would like to briefly introduce that. They have filed an information disclosure lawsuit. And the reason why they filed the lawsuit was because the victims, they are trying to figure out if responsibility lies for the Japanese government or the Korean government. Because those two governments are responsible. And the Japanese government telling them that, the Korean Hibakusha, they should file the lawsuit against the Korean government instead of fighting the lawsuit against the Japanese government. So that is why they filed the information disclosure suit, and they have been able to win this lawsuit. So the complete disclosure revealed that nothing in the documents had any record relating to the atomic bomb victims. And as a result, the Civil Government Joint Committee announced that serious human rights issues, including atomic bomb victims' rights, were not subject to the Korea-Japan settlement agreement, and that the Japanese government still has the legal obligations. Can you move down a little further? So even after the announcement of the civil government joint committee, the Korean government did not negotiate with the Japanese government for the relief of KABV. And from now on, so even so the Korean government admitted that they are going to sincerely negotiate with the Japanese government for the relief of hibakusha after this court decision. And that is why after that, the Korean government moved on their struggle to the constitutional petition with the Constitutional Court of Korea. It's a little bit complicated, so it's difficult to explain. So if you can read the text later on, that would be great. So the English, I would like to show the English part and Japanese part of this part. And can you move down a little further? So as a result of the constitutional petition with the Constitutional Court of Korea, Korean government said that they are going to work hard to negotiate with the Japanese government. However, their failure to do so is in breach of the constitution. So that was the content of the lawsuit. So next, I would like to move on to the lawsuit against the US government and corporations. So in 2017, August 3rd, so Korean victims and their descendants, they filed a lawsuit, the claims against the US government, 3 US companies, DuPont, Boeing, and Lockheed Martin, and the Korean government as respondents. And then there were many processes that followed after that. And on April 30th, 2021, Seoul Central District Court dismissed the case without prejudice on the grounds of the dismissal of the victim's legal aid application of the failure to deposit bond for the excessive amount of litigation costs and of the international service issues. And apart from the case, right now in the United States, a civil court case is in the process to determine whether the use of atomic bomb is a violation of international law. So next is the establishment of the Korean Atomic Bomb Victims Support Act in the parliament in South Korea. So the Korean victims, they have been tried to be remedied through legislation, and the law was successfully enacted in Korea, which is the Special Act for Support for Korean Atomic Bomb Victims. On March 19th, 2016, it was enacted in the National Assembly of Korea. So this special law in South Korea, it's difficult to explain everything in this law, but it is to establish committee to investigate actual conditions of hibakusha in Korea. And then they also decided to create monument and also to create a ceremony for victims in Korea. It's difficult to explain everything, so if you can read those texts later on, that would be great. So I would like to move on to future tasks. So right now, Korean hibakusha are currently neglected without receiving proper remedies from the US, the Japanese and Korean governments, and then they are opening some ways for their rights through eliminating the discriminatory nature of the Japan's atomic bomb survivors support law. So in Korea, although the National Assembly enacted the support law in 2016, a proper survey of the situation remains as a task for the future. So investigation will be held from now on, we hope. And as I said before, for the relief and the rights of Korean hibakusha, agreeing to the fact that the two governments of Korea and Japan did not negotiate on the atomic bombing damage in 1965 should be the start. And we should put the pressure of the Korean government and forcing them to start the negotiation with the Japanese government, which is very important as our task. And then they have to negotiate and they have to decide to give relief to hibakusha in Korea. So your time is almost up. So that's my last paragraph. I would like to conclude my presentation by saying that so the TPNW in Article 6, we hope that based on the Article 6, we will be able to create a framework for the actual relief for hibakusha. And it costs, in order for us to create investigation frame, we have to have certain fund to give relief to survivors, not only in South Korea, but also in North Korea, who have no relief. So thank you for your kind attention.
Thank you very much, Mr. Bongtae. So the final speaker in part 1 is Mr. Naito Masayoshi, Vice President of JALANA. He will speak about the struggle of the Bikini victims, Bikini testing victims. He will also show the video.
Thank you for your introduction. I am Masayoshi Naito, a Vice President of the Japanese Association of Lawyers Against Nuclear Arms, JALANA. As an attorney, I am representing surviving fishermen and bereaved family members who were affected by the radioactive fallout in the Marshall Seas. The Castle Bravo, a hydro bomb test conducted in 1954 at Bikini Atoll, is very famous for affecting Japanese fishing boat Daigo Fukuryumaru, Lucky Dragon No. 5, by the fallout. All crew members on board suffered from radiation symptoms, and consequently, one crew member passed away in September 1954. This disaster incident prompted a large anti-nuclear movement in Japan, as Mr. Sasaki introduced, which led to the foundation of Nihon Hidankyo, Japan Confederation of ANH bomb sufferers organizations. Hidankyo played a pivotal role in the adoption and entry into force of the TPNW. What I would like to introduce And I would like to know and recognize it that fishing boats affected by the US nuclear tests were not only Lucky Dragon. From March to May 1954, the United States conducted a series of 6 hydrogen bomb tests in the Marshall Seas. The number of fishing boats being affected was up to 1,000, but they have been ignored and abandoned. I'm going to introduce a video testimony message of Setsuko Shimomoto, a daughter of affected fishermen. The video shows that in addition to those residing in the impacted islands, nuclear tests affected the fishermen working near the Marshall Islands. That means use of nuclear weapons bring not only massacre of enemies, but also long-lasting sufferings and unjust death to innocent people. Please watch the video. Thank you for your attention.
はじめまして。私は高知市の下本節子です。出身は高知県室戸市です。父親が室戸のマグロ漁船で働いていた1954年3月、米国による水爆実験で被爆しました。室戸は戦後、遠洋漁業が盛んで、100トン級の小さな漁船がマーシャル諸島周辺へたくさん漁に行っていました。金が欲しけりゃ船に乗れ、命が惜しけりゃ船には乗るなと言われるほど、当時は命がけの過酷な仕事でした。米国によるマーシャル諸島の水爆実験は、1954年3月から5月にかけて6回、その後も継続されて、計67回の大気圏内実験が行われました。汚染した魚を廃棄した日本の船は、延べ990隻以上。被爆した船員は、延べ1万人以上と推測されます。しかし、船員たちは被爆を知らされなかったり、口止めされたり、様々な事情から事件のことを黙っていました。翌年1月、日本は米国からの200万ドルの見舞い金で政治決着しました。被災者であるマグロ漁船員は、第五福竜丸の乗組員以外は被災の追跡調査もせず、ビキニ事件は第五福竜丸事件として矮小化されました。米国への損害賠償請求権を被災船員の了解も得ず、日本政府は放棄してしまったのです。被災した高知県の船員や遺族が2016年2月、労災の申請者12名を、5月には船員の救済を放棄して調査資料を隠し続けた日本政府の責任を問う国賠訴訟、原告45名に踏み切りました。なぜ被災から60年以上も経って国の責任を問う行動を起こしたのか。それは1985年に畑高校生ゼミナールの生徒たちが地域の聞き取り調査を始めたことで、長年隠されてきたビキニ事件が明らかになったからです。きっかけは、長崎とビキニで2度被爆して病気になり、27歳で入水自殺した藤井節也さんのお母さんとの出会いです。高校生たちは高知県の漁村を回り、たくさんの漁船が被災していたことを知ります。室戸でも室戸岬水産高校の学生、谷脇正康さんが実習船で被爆し、7ヶ月後の12月に20歳で亡くなっていました。私の父も60歳で胃がんの手術をし、78歳の時、胆管がんで亡くなりました。父と同じ船で働いていた南さんは、被爆から13年後、 46歳の時、肝がんで亡くなっています。たくさんの船員が被爆が原因としか考えられない病気で亡くなっています。旗ゼミの顧問だった山下正俊さんたちが30年以上調査を続けて、行政にも働きかけ、資料の開示を求め続けてきました。2014年、日本政府厚労省がマグロを廃棄した漁船や被爆線量を記載した資料を公開しました。また、広島大学の研究者チームが船員の歯や血液検査を実施、科学的に被爆の実態を解明しました。しかし、労災申請は有識者会議の健康被害を与えるほどの線量ではなかったとする見解によって不払いが決定され、国賠訴訟では原告の訴えは棄却されました。国賠訴訟の原告団長だった増本一馬さんは、二審判決の1週間前に亡くなりました。奥さんは、一馬さんが次から次へと病気になるので不思議だったけれど、核実験で被爆していたことが原因と分かり、納得できたと話しています。2020年、私たちは労災を認めない全国健康保険協会と、船員を救済せずに放置してきた国への損失補償請求の2つの裁判を新たに提訴しました。ビキニ事件の船員の被爆を認めず、核の平和利用を推し進めてきた日本政府は、福島原発事故が起きたにもかかわらず、原発の再稼働を進めています。高知県の隣、愛媛県の伊方原発も2021年12月に再稼働しました。また、福島の放射能汚染水、アルプス処理水の海洋放出を決めました。放射能被害を矮小化する日本政府は、米国に追随し、地球規模の環境破壊を続けています。また、戦争による原爆の被爆国であり、未解決のビキニ水爆実験被災者がいながら、核兵器禁止条約に署名しようとしません。今回、米国や世界の核被害者の皆さんや支援者の方に、高知県のビキニ核被災のことを知ってもらう機会をいただき、感謝するとともに、ビキニ核被災者と世界の被爆者の連帯が進むことを期待します。皆さん、聞いてくださってありがとうございました。下本節子でした。
That's the end. Thank you very much for introducing very important lawsuit case. We take up one question to Mr. Chebonte of South Korea. How the U.S. corporations were selected, I think that was a question directed to me. So these companies were involved or contributed to the producing of the atomic bombs. So Boeing, B-29 producer, which dropped the bomb, and DuPont and Lockheed Martin were responsible for producing the atomic bombs around that time. Thank you very much. So we would like to conclude this part one, session one. Thank you very much for the presentation to all the panelists, and thank you for questions from the audience. I have researched at Nara for a long time to know what has happened and how the suffering of the people have been concealed. And I made a research at the National Archives of the US. And there is an important word. Preserving past is to protect the future. As Ms. Mori's opening remarks said, and other panelists said, this webinar is trying to think together with lawyers and people from around the world to confront the past and to protect the suffering of the people, and protect the people from suffering and protect the future generations, especially by using the GPNW.